In design and construction disputes, the decision makers, the business owners, have really no choice other than to rely on the information that is provided to them about the claim from their employees. And that creates a bit of a paradox, a bit of a conflict, because in many instances, it's these frontline employees, these project managers, the ones that are involved in the dispute, that had a hand in creating the conditions that led to the dispute. Maybe they're responsible for a bid bust, or perhaps they refused to accept the change order that should have been accepted, and now there's some dispute with mechanics liens and other collateral problems. The paradox is that these employees might be concerned about their job security. They might be concerned about their bonuses. And initially, they may be inclined to not give it straight to their bosses, to the project executives, to the people that own their businesses, and say, hey, I made a mistake, and this is something that we shouldn't fight. This is something that we should deal with in some other way. And what I found in design and construction disputes is sometimes the business decision makers, the ones that will make a decision to either settle the claim or decide to go fight it out in court or arbitration, they don't learn the truth about what really happened on the project until too late. There were circumstances where I have litigated claims in federal court, and for years made allegations about how this is what the other side's frontline people did. And it wasn't until after we were deeply into scorched earth litigation that we were able to convince the other side to have a mediation where I could get in the room with the business decision maker, the owner of the other party, and show this person, I have on video evidence of exactly what I have been alleging for years your employees did. And so the urge for business owners to listen to what they're being told by their employees, which in many cases is inaccurate or self-serving, is very powerful. And it's a shame that sometimes we have to be deep into litigation before we're able to get through to our adversaries and help them understand what the reality of the circumstances are. And so one thing that I have found that can help to prevent this situation, that can help to prevent brewing claims from developing into full-fledged claims, is a concept known as step negotiation. And a step negotiation clause is something that you would put into a design or construction contract. And it would say something along the lines of, if a dispute is not resolved in the normal course of business by the frontline workers, by the project managers, if one party wishes, they can give notice to the other party that they're invoking step negotiations, and then executives of both parties who are at least one step higher in seniority than the frontline people who were unable to resolve the dispute themselves, people who are one step higher, which is where the name step negotiations comes from, will get together. They will meet in person or perhaps telephonically at a mutually acceptable time and place, and they will, within a certain period of time, 10, 20 days, after receiving the notice, exchange relevant information, that's necessary to try to resolve the dispute. And this is something that really helps because it takes out of the equation people who might be interested in defending their own mistakes or sugarcoating the reality by stepping one level up to their supervisors who might not have the same concerns, the same self-interest, the same worry that if they're honest about the fact that they made a mistake, they could lose their job or their bonus. It creates a dynamic where the business decision makers are able to say, okay, well, this is easy. One party made a mistake, the other party, is perhaps asking for more money than they're entitled to. Let's just figure out a business resolution and move forward without the need to get into mediation, arbitration, or litigation. Now, if step negotiations fails, then of course the parties can make a business decision to go on to the next step, which could be mediation or arbitration or litigation. But step negotiations I have found is an incredibly valuable tool. I try to include it in all the contracts that I draft for a variety of reasons, including the fact that these negotiations are typically confidential and they're typically inadmissible. And so the parties really stand to lose nothing by coming together in a little bit of a different way than they may otherwise communicate with one another to see at the beginning of a brewing dispute, whether it is possible to achieve early cost-efficient dispute resolution and to enable the business decision makers to make a knowing decision about whether it is in their interest to try to settle the claim or whether they're better off moving on to arbitration or litigation.